Thank you, Chief. Court. Then part of in terms of Rule 108, where the High Court makes an order valid that is supposed to then be referred to the Constitutional Court. Alternatively, a party may approach the Constitutional Court in terms of Section 175 of the Constitution. Thank you.
The second question is also in two parts. The first part, what are the exceptions that must be taken into account by a court when deciding whether or not to grant specific performance in a contractual dispute? And the second part, what is the test which a court applies in the determination of an application for absolution from the instance?
Thank you, Honorable Chief Justice. I will start with the second part of the question. In determining whether to grant an application for absolution from the instance, what the court basically is looking at is whether the defendant has a meaningful defense. So if there is no such, then the court may grant absolution from the instance. And also where I think I will leave it at that, Chief Justice. Then I will pass on the first question.
The third question is in three parts. The first part, state any two components of a sentencing judgment. And the second part, how does a sentencing judgment under the sentencing guidelines regulations differ from the previous practice of giving reasons for judgment? And lastly, what is the role of the victim impact assessment statement?
Thank you very much, Honorable Chief Justice. A sentencing judgment is an introduction where the judicial officer will be outlining the name of the offender, the offense for which he was charged, and also his age and gender. It also contains a plea where you are recording the plea that the offender has tendered to court, whether it was a plea of guilty or not guilty. It also allows you as a judicial officer to list any reports that would have been made, be it forensic psychiatric reports, be it medical affidavits. Those are the three components that form part of a sentencing judgment, Honorable Chief Justice. Then the way a sentencing judgment differs from the previous practice of giving reasons is that a sentencing judgment is allowing a judicial officer to apply his or her mind to the sentencing process. Previously, reasons for sentence were just what I would call cursory. Now the sentencing process is now more substantive, and also it allows the judicial officer to take into account all the circumstances which may guide the judicial officer in coming up with a suitable sentence. Then on the third question, Honorable Chief Justice, a victim impact statement, it details the psychological, the physical, or the financial or any other consequences an offense would have had on a victim or any person who is related to the victim. So it assists the court to see or to hear the voice of the victim, and for it to be able to come up with a full judgment where it is considered the impact that the offense has had on the victim. Thank you, Chief Justice.
The fourth question also has two parts. The first part, how have the High Court Amendment Rules 2024 addressed the key concerns of access to justice on the IECMS platform? And the second part, state three ways in which the IECMS has revolutionized civil litigation in Zimbabwe.
Thank you very much, Honorable Chief Justice. On the first part of your question, if you look at Statutory Instrument 81 of 2024, it has placed an obligation on the Judicial Service Commission to ensure that there are e-filing centers at every magistrates court and at every high court. So the creation of e-filing centers means that access to justice has been enhanced, in that people without the necessary gadgets, they can now approach the High Court from the comfort of e-filing centers dotted out throughout the country. Then also The other concern that was raised previously is that there was no platform for members of the public to participate in virtual hearings. Now the rules allow for members of the public to join in a virtual hearing through a court generated link. You also realize that it has placed an obligation on the Commission to ensure that e-filing facilities are also availed to persons in detention. So that is how the new High Court rules have addressed concerns relating to access to justice, Honorable Chief Justice. If I may add, also it has placed obligation on the Commission to ensure that facilities are available for people with disabilities, because those were concerns that were raised about the marginalized community. Then 3 ways in which the ICMS has revolutionized civil litigation in Zimbabwe. At the IECMS platform, Honorable Chief Justice, it allows you to file pleadings from anywhere inside or outside Zimbabwe, as long as you are registered on the system. So what it means is that you don't need to travel to a court physically to be able to file pleadings. You can do that from wherever you are. Also, it allows you to anytime, you don't need to wait for court hours, but however, the pleadings will be accepted during the normal working hours. Then the other issue that has been introduced, Honorable Chief Justice, is that the platform allows for virtual hearings. In that, so the advantage there is that you don't need to travel to court physically. You can have your matter heard from within Zimbabwe or outside Zimbabwe, as long as you have a court generated link that allows you to then participate in the virtual hearings. That would be my answer, Honorable Chief Justice.
Thank you. I will now hand you over to the other commissioners for further questioning. Yes, TCJ.
Yes, thank you, CJ. Good afternoon, Ms. Mushure.
Afternoon, Deputy Chief Justice.
I have 2 questions for you. The first one is a short question. Your CV suggests that you were never a regional magistrate. Is that true?
I was never a regional magistrate, but when you're a chief magistrate, you have the same jurisdiction.
No, I know. Just that when I was reading your CV, that was missing.
Thank you, Chief Justice. Thank you, Deputy Chief Justice.
Perhaps you were going to anticipate what I'm going to ask now. Do you think that may constitute a detraction from your preparedness to be a judge of the High Court?
I don't think so, Honorable Deputy Chief Justice. I want to believe the various portfolios that I have occupied in the administrative and also in the judicial have prepared me enough to be able to sit on the High Court bench. You realize that if you are a chief magistrate, you have jurisdiction which is equal to that of a regional magistrate and also a provincial magistrate. So I have sat in court as a chief magistrate and I've determined matters. And also you realize that I've also been in charge of the Legal Services Department of the Judicial Service Commission, and I've also been a registrar of the High Court. So I want to believe the positions that I've occupied have allowed me to prepare myself for the task I had. Thank you.
Yes, thank you for that answer. The second question pertains to the complaints. Some of the complaints received from the public, among others, that you exhibited cruel, inhuman, and degrading treatment, or you perpetrated that on members of staff. and that you also interfered with the decisions of magistrates. It seems these complaints are anonymous, and you have denied that is the case, but one just wonders, why would people raise such serious allegations?
Thank you very much, Honorable Chief Justice. Honorable Deputy Chief Justice, I think as you have already commented, those allegations, as if they had been substantiated, I want to believe they would be really serious. But if you look at the complaint about me being cruel and inhuman, is just one sentence which does not have any substantial information for one to be able to then respond. But as I responded in my response, DCJ, I have tried as much as possible in my interactions with members of staff to treat them professionally. I want to believe if I had been given an opportunity, maybe with the benefit of sufficient information, I would have been able to respond to that. The same applies to the matter that you referred to, Honorable DCJ, that is someone just mentioned a name. There are no details. You don't even know in which court the appeal was then subsequently overturned. And I want to believe if there was any substantial information, it would have allowed me to apply my mind to it. But in the absence of that, I want to believe I've tried as much as possible to conduct myself in a professional manner, and as I've also commented in the response, that at the time that I'm alleged to have interfered with the magistrate in question, I was not even at the magistrate's department. I was a deputy secretary, and my only interaction with members of the magistrates department was very limited to the M&E visits that we used to do. That will be my comment, DCJ.
Yes, thank you.
Thank you, Chief Justice, and good afternoon, Mrs. Mushure.
Good afternoon, AG.
Yes, I've got one question to you. Now, bearing in mind what the court rule entails, can you please give us 3 examples of situations where the court should exercise caution with the evidence of a particular class of witness? That's the question.
Thank you very much, AG. The court should exercise caution when dealing with evidence of children because they're young persons, they are bound to some imaginations, and the court should exercise caution when dealing with evidence of children. The court also should exercise caution when dealing with accomplice evidence because obviously this person is an accomplice, and there's a he or she may be wanting to absolve themselves in the case at hand. The court also should exercise caution when dealing with evidence of a single witness. It has been described as a boxing ring situation where it is the word of the accused person against the word of the witness. So in such a scenario, the court is encouraged to exercise caution, but that does not mean that evidence of a single witness is not admissible. Thank you.
Thank you.
Thank you, Chief Justice, and good afternoon, Mrs. Mushure.
Afternoon, Commissioner.
Now, I do have one question for you, and it's as follows. What factors should the High Court take into account before interfering with unterminated proceedings in a lower court?
Thank you very much, Commissioner. The general rule is that a court will not readily interfere with unterminated proceedings of a lower court unless if the court is of the view that there is actually a gross misdirection on the part of the judicial officer, and if the court does not interfere with the unterminated proceedings, there will be a gross or a serious miscarriage of justice that would occasion a serious prejudice on the party who is seeking the court to interfere with the unterminated proceedings. Thank you.
Thank you. Thank you, Chief Justice.
Thank you. Thank you, Chief Justice. Good afternoon, Mrs. Mushure.
Afternoon, Commissioner.
A complaint has been made that your office was issuing invalid marriage certificates. Can you explain that?
Thank you very much, Commissioner. Stationery for marriage certificates comes from the Registrar General's office. So when there was a change in law, we contacted the Registrar General's office on the need to supply us with the corrected stationery. And the Registrar General's office then said that you may continue using those marriage certificates in the form that they were, because when you solemnize a marriage, then the certificates, you submit them to the Registrar General's office. So they said continue submitting them in the manner that they were, and they were being accepted in that manner. Only in January 2024 was did the Registrar General then say, may you please cancel out the chapter 5.11 and indicates that the marriage is being solemnized in terms of chapter 5.17. So what is happening now is that judicial officers or magistrates who are solemnizing marriages, they cancel out the chapter, they insert the new chapter by pen, and they sign, and we submit them, and they're being accepted in that form.
Thank you, Chief Justice.
Thank you, Honorable Chief Justice. Good morning, Mrs. Mushure. Oh, it's good afternoon, actually. Mrs. Mushure, what prompted you to accept nomination for the High Court bench, especially considering that as Chief Magistrate, you lead quite an empire?
Thank you very much, Commissioner. I think you come to a point when you decide that it is time to grow, and this is the only way that I can grow. I think it's an issue of self-actualization. Yes, I do lead an empire, but for me to be able to grow, I need to move to the next level. The other thing, Commissioner, is that I've always wanted to be a judicial officer, and when the time was right, and I then believe that I think for me to be able to grow professionally, it is time that I then take on the next challenge. Thank you.
Thank you, Honorable Chief Justice.
Thank you, Honorable CJ. Yes, Mrs. Mushure, I have two short ones for you. What guides your decision-making process? What guides your decision-making process?
Okay, thank you very much, Honorable Judge President. What guides a judicial officer's decision-making process is the evidence that has been placed before the court. You look at what the law says in relation to that. You look at the facts, then guided by that, then you apply the law to the facts, then you come up with a decision.
Very well. If we do recommend you, how are you going to build relationships with fellow judges at the High Court?
Thank you very much, Honorable Judge President. I think I may say that I'm in a good space where I have interacted with judges of the High Court in my capacity as Registrar of the High Court. And, I don't think it's a problem for me to build a relationship with judges of the High Court. I also believe that I will be a junior judge, and I will be guided by my superiors, and also the relationship that I would build will be based on mutual respect with each other, and also the guidance that I receive from my superiors. Thank you.
What is your understanding of the concept of collegiality?
Okay. Thank you very much, Honorable Judge President. While the concept of collegiality is that judges, they appreciate that they have a common interest, and that common interest is the dispensation of justice. But sometimes you may have different opinions or different views on the law. What it means is that you then are able to accept different opinions from the other judges in a respectable manner. So the guiding principle is that judges have a common interest, and that common interest is the dispensation of justice. And then you also have to say, maybe even in a matter where you are sitting as 3 judges, you then defer to the opinions of the other judges. It's not like it's my way or no way at all. A judge in the spirit of collegiality should be able to then accept a view from another judge and defer to that view. That is my understanding, the Judge President.
Mrs. Mushure, good afternoon.
Afternoon, Commissioner.
I've noted that on your CV you have attended various professional development courses. Indicate to us the mechanisms that you have personally employed to ensure that the JSC continues to support the capacity development initiatives for magistrates. Maybe just 2.
Thank you very much, Commissioner. If you look at Section 165, subsection 7 of the Constitution, it obliges judicial officers to develop themselves and to keep abreast with changes in the law. So what I have done as a chief magistrate is to ensure that there is training that is done for magistrates, and it's actually a requirement in the performance management contract of the judicial officers who had various divisions and various provinces. And also, I also love training, and I've also made it a point to conduct trainings as well. Thank you.
Thank you. You do mention that you champion performance evaluations. How do you ensure that they are fair and that they are actually perceived to be fair as well?
I think it's a question of monitoring, Commissioner. You have to ensure that when you performance evaluation or performance management system in place, you constantly monitor that performance management system, and you also have to ensure that the goals that you have set they are smart, they are achievable, they are specific, they are measurable, and also they are time limited. So when you look at those things, you are ensuring that the performance evaluation systems that you have put in place, they are actually achievable and they are fair, and you are not placing an onerous task on a person to perform beyond their capacity.
Thank you, CJ. Thank you, Mr. Mushure.
Thank you. Mrs. Mushure, you were appointed Chief Magistrate just under 3 years ago. Correct. And alongside your other duties, you do administrative duties. That would mean you are not in court most of the time. You are probably, in terms of your time, most of your time you will be doing administrative duties. Do you then think that by the short time that you have been a Chief Magistrate, you have gathered enough to make you to be appointed a Judge of the High Court?
But thank you very much, Commissioner, for that question. I appreciate it. I want to believe I have gathered enough experience for me to be able to be appointed as a judge of the High Court. You realize, Commissioner, that as you have rightly put, that as a Chief Magistrate, you also have a judicial function. So what it means is that I have sat in court and I've presided over matters, and it's not only when I was a Chief Magistrate, but before, when I was a magistrate, I was presiding over matters. You also realize, Commissioner, that I have been a head of policy and legal services in the JSC. I've been a deputy secretary in charge of the policy and legal services department, and I've been able to interact at a senior level with senior counsel and advocates, and we have presented cases in the various courts, from the apex, which is the Constitutional Court, at the time when I was heading the legal services department. You also realize that there is an analogy, Commissioner, between being an administrator and being a judicial officer, and that analogy is that you are required to make decisions. The fact that I've been appointed on various administrative roles, it means that the employer has seen that I'm fit for the job, and I'm able to make quick decisions, albeit administratively. So I don't think, coming from that background, it will be difficult for me to be able to fit into the judicial role, because it also involves making decisions, so I should be able to fit in that. And also, if you look at my academic transcript and also the results of the first phase assessment, I think they speak to my ability to be able to deliver as a judge. Thank you very much.
I just want to follow up on the issue of marriage certificates.
Commissioner.
Did you have to wait for the registrar to tell you to change, to put those stamps and endorse on when the law had already been changed, or it should have been the other way around?
Thank you very much, Commissioner. I appreciate that question. No, I was not supposed to wait. What happened, Commissioner, is that when the law was changed, I made an effort to speak to the Registrar General to ensure that we the relevant stationery. The unfortunate part is that this is stationery that is administered by another office. They give us the stationery. So I made that effort, and I contacted them to say that we are no longer able to use these marriage certificates. They need to be changed. They indicated that they appreciated that they need to be changed, but probably because of constraints, they could not change them. So they then gave a specific instruction that you are supposed to continue using the marriage certificates in the form that they are, and we continued doing that. It was only in January 2024 that he then issued another letter saying that can you continue using them, but for now, can you now cancel out the marriage chapter and endorse the new chapter? And he indicated that this is a stopgap measure whilst they are making arrangements for the new stationery. You then, if you are guided by the people who are providing you with the stationery, then you then have to implement, because what it meant is that we would say that we are no longer solemnizing any marriages. Thank you, Commissioner.
Thank you, Chief Justice. Mrs. Mushure, good afternoon. Mrs. Mushure, you are a part-time editor of the law reports. My question is, the experience that you have gone through editing law reports, has it prepared you in any way to be a judge? And if so, how?
Thank you very much, Commissioner. Indeed, I want to believe that task has prepared me to be a judge in as far as what is involved in what would be deemed a good judgment. You look at a number of judgments, and you look at if they are introducing a new principle of the law, then a judgment is then deemed reportable because of that. So it has exposed me to various facets of the law, and it has also exposed me to good judgment writing skills, and I want to believe, yes, it has prepared me for the task ahead should I be appointed.
Thank you, Chief Justice.
Yes, Mrs. Mushure, what have you been hearing any cases of late as a chief magistrate?
Of late, yes, I think I dealt with cases this year. I must have dealt with I dealt with cases this year.
Are you able to give us names? What cases, big cases, or you're just talking about the small cases that have no real consequences as such to the nation? What cases have you dealt with?
Okay, I've dealt with a case, I think it was on the illegal possession of drugs, and I've also dealt with a case where a person was accused of, it was a fraud case where a person was accused of having forged a name on a birth certificate so that they would gain succession rights that they did not have.
Did you complete those cases?
Yes, Honorable Chief Justice.
Are you having any outstanding cases?
No, I don't have any outstanding cases, Chief Justice. No, I don't.
I think we're not dealing with, is it Mufumira, is it?
No, we haven't, I haven't been dealing with that. We haven't started it, Chief Justice.
You didn't start it?
No.
Is it?
No.
Oh, I see. Yes, thank you. We have come to the end of your interview. You are excused.
Thank you very much, Honorable Chief Justice. Thank you very much, Commissioners, for the opportunity.